thank you all for coming. I'd like to thank the conference organizers for having this paper on the program. This is joint work with Pat Akey at the University of Toronto. And in this paper, we're studying externalities associated with limited liability. Now, I think it's pretty non-controversial to say that limited liability for the owners of corporations has played a critical role in driving economic growth and the development of capital markets. However, it's also obviously the case that there's an inherent moral hazard problem associated with limited liability. That is, a firm's assets may be insufficient to cover the claims of creditors, and this in turn may incentivize privately profitable yet socially costly behaviors. Now, we can think about all sorts of mechanisms that help to mitigate this moral hazard problem. And so there's things like minimum capital requirements for financial institutions, all sorts of different ex-ante regulations on firms, and our focus, which is on legal liability for the owners of corporations. Now, specifically, owners of corporations are liable for the acts of the corporation in limited circumstances. And so this is the idea of piercing the corporate veil. Normally, we think about a veil that separates the owners of a corporation from a corporation, but in limited circumstances, courts can pierce this veil. Now, I want to stress this is normally a very difficult thing to do. It's most common with closely held corporations and in the parent-subsidiary relationship. Now, in this paper, we're going to study parent liability for subsidiaries' environmental costs. That is, we have a parent corporation who owns a subsidiary corporation. The sub has some sort of environmental disaster. The question is, does the parent have to pay to clean this up? And specifically, we ask, how does limited liability in the parent-sub context affect subsidiaries' incentives to pollute and ultimately conduct different types of economic activities? Just to preview where we're going with this paper, our setting is going to use a Supreme Court case, US v. Best Foods. And so this strengthened limited liability protection for some parents under Cercla, which is an environmental law I'll talk about some more in a few slides. And specifically, this case overruled circuit courts that had previously adopted different standards for this question of, do parents have to cover the environmental cleanup costs of subsidiaries? And then our methodology is pretty simple. We're going to exploit this circuit split in a diff and diff framework. Just to preview our main findings, we find that stronger limited liability protection is associated with a 5 to 9% increase in toxic emissions, and this is specifically driven by less solvent subsidiaries, where it's less likely that they'll be able to handle the costs associated with a large environmental cleanup. Now the question, where do these emissions come from? Why do we see them? We find evidence of lower investment in pollution abatement, but we don't see any evidence of a change in production or of a reallocation across plants that have the same parent. And ultimately, our findings are driven by parents with a high risk of distress, and this is consistent with a risk-shifting or harm-shifting motivation for the findings. And so overall, this paper highlights this moral hazard problem associated with limited liability protections. All right, so first I want to jump into some institutional background real quickly. I mentioned Cercla before. This is the Comprehensive Environmental Compensation Response and Liability Act, more informally known as Superfund, though as I'll explain in just a minute, this is a bit of a misnomer. Cercla was passed by Congress in 1980, and it was specifically a response to the Love Canal disaster, which at least at the time was considered one of the biggest environmental disasters in US history. And its goal is to address the ex-post cleanup of toxic sites. And so this is in contrast to other types of environmental regulations, things like the Clean Air Act, the Clean Water Act, that impose ex-ante restrictions on firms. And there's currently 1,300 sites on what's called the National Priorities List, which are eligible for cleanup under Cercla. Now, in terms of what was the legislative goal of Cercla, well, it's twofold. First, the goal was to clean up legacy sites. And so according to a 1979 report from the EPA, there was something like 30 to 50,000 abandoned sites across the country, a handful of which posed a public health risk. Second, just like any other type of ex post penalty, a goal of Cercla was to deter the creation of future sites. And so this is, we can see this from a quote from Senator Stafford from Vermont from the time Cercla was passed, saying that the law would induce the highest standard of care. More recently, the EPA said that Cercla creates powerful incentives to deter risky industrial and commercial practices. Now, speaking of incentives, cleaning up these Cercla sites can be costly. And so, for instance, with Love Canal, the cleanup took 2 decades and cost an inflation-adjusted $400 million. And this isn't necessarily an outlier. We can look at some more recent examples, and we see cleanup costs routinely are in the hundreds of millions, if not billions of dollars. All right, so the question is, we have this toxic site and an expensive cleanup. Who has to pay? And so there's 2 statutory mechanisms under Cercla to address this question. First is the Superfund. And so Superfund is a trust fund that pays for cleanups when a responsible party is either unable or can't be identified. And so, for instance, they call this midnight dumping, where there's pollution that shows up at a site, but it's not entirely clear how it got there. Second are the liability rules under Cercla. And so specifically, Cercla imposes liability on the owners or operators of toxic sites. Now, if you sort of read about the legislation, it comes across that Cercla was sort of hastily drafted. It was the result of a last-minute compromise. This term owners or operators is never precisely defined. And so courts had to grapple with this idea of, well, are parent corporations considered owners or operators under Cercla? And so eventually we had circuit courts across the country that adopted different standards to address this question. And so specifically, circuit courts adopted 3 different standards. The first was the ability to control standard, which says that parents are liable for environmental cleanup costs of subsidiaries if they had the power to control the activities of the polluter. Now, given that a subsidiary is at least 51% owned by the parent corporation, this seems to open the door towards lots of liability for parent corporations. Next was the actual control standard, and so this is sort of an intermediate ground. And so this imposed liability on the parent if the subsidiary did not act independently. And so, for instance, things like overlapping directors between a parent and a sub, which aren't necessarily grounds for piercing the corporate veil, at least in Delaware, could be grounds for actual control, for liability under this actual control standard. And finally was the veil-piercing standard, where circuit courts said that parents are liable for cleanup costs if the corporate veil can be pierced under state corporate law. And so we have these 3 different standards. Here's a map showing the circuits that adopted the different standards. In red is the ability to control standard. In blue is the actual control standard. And then gray is veil piercing. So we have these different standards. Eventually, the Supreme Court steps in 1998. This is the Best Foods case. And Best Foods rejected the ability to control and actual control standards. And so the court said that parents are liable for cleanup costs only if the corporate veil can be pierced under state law. And again, this is a difficult thing to do, requires showing some sort of abuse of the corporate form, things like fraud, or if the sub is an alter ego of the parent company. Now, the Supreme Court also made one other exception here, where if a parent directly operated the facility of a sub, this could also be grounds for liability. And so these would involve things like a joint venture, perhaps, between a parent and a subsidiary. All right, so briefly the methodology and data I'm using in this paper. Like I said, we're using this Best Foods decision in a diff and diff framework. And so Best Foods is, we can think about that as the interaction term in a normal diff and diff. And so this is an indicator that equals 1 after the decision for the subsidiaries that are located in circuits that use the ability to control or actual control states. And so we're just merging together these ATC and AC groups for our treated group. We can also just look at the ability to control firms separately, and the analysis is very similar. One thing I'll note is that the liability standard here is going to be based on the plant's location. That is, we don't really have significant forum shopping concerns here. This is something that we've verified empirically, looking at a random sample of 100 cases. 99 were brought in the circuit where the plant is located. This is something we can talk about some more in the discussion if you'd like. In terms of the regression specification, we're including plant fixed effects. Our data is at the chemical by plant level, so we also have a chemical by year fixed effect, and so we're looking within chemical in a plant. And then we also include a parent company by year fixed effect. And so essentially what we're doing here is we're looking at two plants. We're comparing two plants which share the same parent. One is located in a circuit that used either the ability to control or actual control standard, one of which is located in a circuit that already employed this veil-piercing standard. Our data comes from the EPA. We have plant toxic emissions from the toxic release inventory. And so this gives us the pounds of groundwater and air emissions at the chemical level. In total, we have close to 8,000 parent corporations, which on average have 3 subsidiaries using 4 chemicals. We have information on pollution abatement activities from the P2 database. And so this allows us to construct an indicator for different types of abatement activities that plants can take. And finally, we have a measure of plant production from the same database. And that is facilities report a production ratio, which is the ratio of the final output for whatever a chemical is used for this year relative to last year. All right, so let's jump into the results. First, we asked, well, how do these liability standards affect the emissions of subsidiaries? So I haven't really gotten into the details here, but the main focus of Cercla is on ground pollution. And so you can think about sort of drums of toxic waste that have been buried in the ground. It's essentially what was happening with Love Canal. And so examples of ground pollution include things like landfills, surface impoundments, injection wells where you shoot toxic waste deep into the ground, and then things like spills and leaks released into the ground. And so our dependent variable in this table is the natural log of 1 plus the pounds of ground pollution. In the first 2 columns, we're looking at the sample of all subsidiaries. In column 1, we have plant, chemical by year, and parent by year fixed effects. And then in column 2, we add industry by year fixed effects to this as well. And here we see that there's an increase in ground pollution for the treated firms relative to the control firms. Next, we look at the sample of subsidiaries that have a publicly traded parent. Again, we see a positive effect. The magnitude here is even larger. And so this is consistent with some previous research that says that public plants have a higher, are more likely to have higher emissions. And then finally, in columns 5 and 6, sort of as a falsification test, we look at the sample of plants that don't have a parent company, and so they're not subsidiaries. And as we would expect, they don't appear to be affected by the best foods decision. Now, in terms of the economic magnitudes of these coefficients, we have to be careful how we interpret these. We're using the natural log of 1 plus the pounds of emissions. So there's a lot of zeros in the data, so this doesn't quite have the nice interpretation that just taking the log of the dependent variable does. But if we compare our coefficients to the sample mean, it's an increase of about 5 to 9% in terms of economic magnitude. And so a sizable effect. In terms of looking at the coefficient dynamics, consistent with the parallel trends assumption for this setting, we don't see any evidence of an upward trend prior to the best foods decision, but though it begins to increase afterwards. And it's statistically significant starting in years 3 and 4. We do a bunch of robustness tests. I don't have time to get into all the details. We can omit any individual circuit cord. It's not driven by one circuit. Like I said before, we can just limit the treatment group to these ability to control plants. And then we can use different types of outcomes, such as the proportion of ground pollution. And then we can do a number of things to account for potential problems with our standard errors. All right, so now we want to think about why are emissions increasing? And so we consider 3 potential channels here. And so first, higher emissions may be the result of decreased abatement And so we can think about this as stronger limited liability protections, weakening incentives to invest in different technologies that reduce emissions. Second, the increase in emissions may result from higher production. And we could think about this as stemming from the fact that limited liability protections essentially decrease the cost of polluting. And then finally, another potential channel is a reallocation across plants that share the same parent. This is something I won't get into here, but I will say that in the paper, we don't really find strong evidence consistent with this channel. All right, so first, abatement. Pollution abatement costs are a sizable expense for industrial companies. Like I mentioned before, we can measure abatement using this P2 database. And so specifically, we construct indicators for the most common types of abatement. And so these are abatement related to the operating practices, so things like improved record keeping, and abatement related to the production process, so things like modifying equipment or optimizing reaction conditions. What we find here is when we look at both types of abatement, we don't see strong evidence of an effect for abatement related to operations, but we do see evidence of an effect for abatement related to the production process. And again, we see this for both the sample of all subs as well as subsidiaries with the public parent. And the economic magnitudes here are substantial. It's a decrease of between 12 and 25% in production process abatement. Next, we think about economic activity. Like I mentioned before, we can think about best foods as decreasing the cost of polluting, in which case we might expect to see an increase in production. And we measure production using this production ratio from the EPA. We don't, however, see evidence of an effect on the production ratio. And so specifically for the sample of all subs, as well as subs with a public parent, our coefficients are positive, but they're not statistically significant. Furthermore, we can look at an estimate of plant employment from Dun & Bradstreet. And again, we don't see any evidence that plants are, for instance, increasing in size by hiring more people. So overall, we don't have strong evidence of an effect on production. So what's going on here? How do we explain this? And so one way to think about this is that this reflects fixed costs associated with future cleanups. And so this is a point that the EPA makes, where land cleanup is distinct from other types of environmental cleanups simply because it has substantial fixed costs associated with it. Now, if we think about a standard economic framework here, if the costs affected by best foods are fixed in nature, not variable, then it's quite natural that we don't see an increase in production stemming from this decision. And in addition, we can think about this as requiring less need for current abatement, which also can have sizable fixed costs associated with it. We conduct two cross-sectional tests to help us think about the results here. And so first, we look at subsidiary solvency. And so parent liability is going to be more likely if our subs are less solvent. And second, we look at parent distress risk. And so firms in distress may have incentive to shift harm to other types of stakeholders. And so just briefly, we find that our results are driven by less solvent subsidiaries. And so we're measuring solvency using a PAYDEX score, which is similar to a credit score for private companies. For both ground pollution as well as abatement related to the production process, we see our results are driven by these plants that are less solvent. And then when we look at parent distress risk as measured by the Z-score, again, we see that our effects are driven by plants associated with parents that are closer to distress. And so again, we can think about this as being consistent with a risk-shifting motivation for the findings. All right, so I am pretty much out of time. In this paper, we are studying trade-offs of limited liability in the parent-sub context. We find that the stronger liability protection is associated with higher emissions, and it appears that the channel driving this is lower investment in pollution abatement technologies. And so overall, our findings highlight the moral hazard problem associated with limited liability, though of course with the caveat that the aggregate welfare effects are unclear here. Thank you.
Okay, so thank you very much for inviting me to discuss this paper. I think the presentation was clear enough. Let me summarize quickly. So it's a Supreme Court case, United States versus Best Foods, that established that the corporate veil cannot be pierced in order to clear, to pay for a cleanup of a bankrupt subsidiary. As a result, they document that pollution has increased by between 5 and 9%. This is related mainly to the investment in abatement, which fell 15 to 17%. I have no problem with the execution of the paper. I think it was carefully done. So I decided to focus on the interpretation, with which I don't fully agree with. So why is that? I want to say that the issues that are raised in this case are terribly interesting. So there are fundamental issues here which are related to the relationship between corporate law and environmental law, to the division of labor between the courts, the regulators, and the legislators, and to the notion of legal formalism, which I think plays a big role in the decision of the Supreme Court. So what are the facts of Best Foods? It's about a subsidiary called O2 of a parent called CPC, that was operating somewhere in Michigan, left behind a cleanup bill that the court says was well into the tens of millions of dollars. The subsidiary went bankrupt. The parent is still alive. The U.S. environmental agencies go to the district court and say, please, can you please pierce the corporate veil? The district court agrees, but then the Sixth Circuit reverses the decision of the district court, and the Supreme Court accepts the position of the Court of Appeal. So what's the legal dilemma? The legal dilemma is that on the one hand, we know that making polluters pay for damages of pollution is a fundamental principle in environmental economics, and is recognized by U.S. law in Section 107 of Cercla. But then there's the problem that the Supreme Court says that it is a bedrock principle in corporate law that a parent corporation is not liable for debt created by a subsidiary. I mean, that's the whole point of limited liability, right? That you can limit the liability to your debt, including to the debt of a subsidiary. Otherwise, what's the point of limited liability? There are rules about piercing the corporate veil, but the court says that this is reserved for exceptional cases, effectively fraud. There was no fraud here. Okay? So the dilemma is between the principle, the economic principle, which is accepted by the law, and the reading of corporate law. And the court says, no, this is not fraud. We refuse to pierce the corporate veil. And that might look, particularly to an economist, that might look like a bit formalistic, but the court decided to be formalistic. So can we, I don't think that you said it explicitly, but it's quite clear that you don't like the decision of the Supreme Court.
No welfare claims.
Come on. You don't like it. Why are we so afraid? You don't like it, and on first read, I didn't like it either. But thinking about it a bit more, I thought that maybe they had a point. So first of all, the question is the following. You said that there's some fundamental moral hazard problem which is associated with limited liability. I don't agree. Okay? Limited liability is a contractual mechanism originally. It was created originally by contract until it was adopted by English law and then by American law. And there are plenty of reasons why we think that this is something that helps business. You are right in saying that sometimes limited liability is becoming a burden, in which case there are plenty of contractual mechanisms to soften or to bypass limited liability when that is necessary. So, for example, it is very common for SMEs to borrow. What have I done wrong?
I'm just signing up for the list.
Okay. So it's perfectly common for SMEs, for owners of SME to give personal guarantees to debt of the SME or to mortgage their own house for a certain loan taken by the company. Okay, so there are contractual mechanisms to eliminate limited liability globally, but to say that for the sake of a certain loan, we are giving away the protection of limited liability because this is good for business. So there is no problem in principle with limited liability, or the way you put it, a moral hazard aspect of limited liability. And I think that this is what the Supreme Court had in mind. Why should we intervene and start to play with principles of limited liability which per se have no problem? What's the problem here? The problem here is purely a tort problem, that when a bank is lending money to an SME, the bank is saying, unless you give me a personal guarantee, I'm not going to extend the loan. In this kind of case, there's no one, or there was in this particular case, no one on the other side that say you have to increase your liability. So the issue is squarely with environmental law or with tort. And the Supreme Court is rightly worried that if we create another precedent, that will have an effect down the line, exactly like the thing that you document. So the question is there an alternative? Well, there is an alternative. You can create a Basel-like regulation that will set up the amount of capital that any company, whether it is a subsidiary or not, because this problem can come up with non-subsidiaries as well. It's not specific to subsidiaries, right? So you can set up a regulation that says this is the amount of capital that a company that is running a polluting operation has to set up, and any debt against this by the environmental authority is senior to any other debt. So there are other solutions. There is even a better solution, which is this. So as Marco said, I invited you to talk about shipping. Here is the shipping, okay? Why shipping? Because shipping is where subsidiaries are used to the limit. Every vessel, every commercial vessel that sails the ship is a subsidiary, is a limited liability company that owns this ship only and is typically owned by a parent company. Now, if you sail into any vessel that sails into the territorial waters of the United States, is required by the U.S. Coast Guard to post this document, which is called the Certificate of Financial Responsibility. And the Certificate for Financial Responsibility says that the insurer a third party, which in this case can also be the parent company. The parent company can give the certificate of financial responsibility. 10 minutes? No, I don't need 10 minutes. I'm done. So we hereby certify, for the purpose of complying with with the Oil Pollution Act and with Cercla, that the vessel owned by and operated by the assurer is assured against environmental damage. Okay. So here's my conjecture. You look at the five years after the decision. I think it's 5 years, right? The first 5 years under the decision, after the decision, my guess is that just as the U.S. Coast Guard thought about how we impose financial responsibility on these companies, the other environmental agencies were looking for similar ways. And I think that that you should look broader and look for the more broader implication of the decision. That is, it is possible, and my guess, and it's only a guess, I don't have the evidence, that's the only piece of evidence that I have, that there was a continuation, that there was a continuous innovation on the side of the environmental agencies to come up with a solution which is actually much better than piercing the corporate veil, right? This is a much better solution, right? So it is possible that at the end of the day, the Supreme Court was right. Maybe it took a bit more time, but it did manage to put pressure on the environmental agencies to come up with effective solutions rather than go for the brute force of piercing the corporate veil. Thank you.
Thank you. That was a really thoughtful discussion. It'll help give us some things to think about. In terms of our interpretation of the findings, I wasn't kidding when I said we're not making a welfare claim. People have tried to sort of push me for what is the policy recommendation coming from this paper. And initially, when we were first writing the paper, we were expecting to find that emissions go up and production goes up, and this speaks to the trade-offs associated with limited liability in that it encourages sort of beneficial economic activity, but there's also negative externalities potentially associated with it. As we saw, we don't find strong evidence of an effect on production, and so I think we had to think hard about why that is and sort of what's driving the increase in emissions. But still, the aggregate welfare effects aren't clear. You can argue that this potentially would affect the cost of capital for firms, for instance. And so we're just I think we acknowledge that we're only really showing evidence on one side of the aggregate effects of what's going on here. In terms of the sort of moral hazard problem associated with limited liability, I certainly agree that there can be mechanisms that sort of mitigate this, sort of the loan guarantees for SMEs that you were talking about. But sort of in a vacuum, absent interventions like that, there still is a moral hazard problem. If I own a firm, I don't particularly care about liabilities that might be incurred that exceed the value of the firm. And in terms of thinking about the broader implications of the decision and other actions that potentially the EPA or other authorities could take here to deal with toxic emissions, I think that's a fantastically interesting question. I don't think it's at all clear theoretically what the best sort of liability regime or other type of intervention that could potentially be taken here would be. And so I think that's something we should think about.
I've taught some of this stuff and been an expert witness in the area a little bit. The Supreme Court, I mean, the irony, of course, is that the Cercla statute was written exactly to do what Oren wanted innovation to do, which is to say to overcome the common law constraints of veil piercing. That's what the statute was written to do, and the Supreme Court's decision otherwise was just, the Supreme Court acting in a peculiar way. And indeed, the solution that Orange suggests, which is in effect a parent guarantee of the subsidiary, is exactly the result of veil piercing, because that's what it functionally amounts to, is a guarantee by the parent of liability by a subsidiary that can't meet its tort law claims. So also the tort law risks are also long tail, and they're of unknown dimensions, so they can't really be insured against in any convenient way. That's in effect why the parent, the liability of the parent is there, precisely because I think the parent could, if it wanted, write a third-party agreement, but it's not an insurable agreement because the moral hazard of the parent controlling the level of pollution by the subsidiary and the uncertainty is the cost of the cleanup, many factors which make it not a contract where insurance could be written to cover losses of this sort. So the Cercla statute was written precisely to deal with the peculiar issues presented by the kind of risks that you identify. And it seems to me the paper shows the wisdom of the statute that was written by the legislature and the lack of the wisdom of the Supreme Court in deciding that it was going to revert to a common law standard which is not its to administer, which varies across 50 states, which has got as many flavors as, M&Ms have got colors. It makes no sense to have anything other than the uniform federal rule. That's what the federal law tried, that's what was the goal of the Cercla standard. And now we have a bit of a mess because states have adopted similar statutes to what would have been the uniform federal standard, and so there are now multiple different versions of the liability regime precisely because the Supreme Court said that we couldn't have a uniform federal standard.
I have no response. Thank you, though. I think that's really insightful. Thank you.
This is a nice kind of a paper for a law and economics group because it indicates something about the different style. To do modeling or to do careful empirical work, you've got to simplify. Lawyers' reaction, lawyers try to deal with the same problem, that is constraining the degrees of freedom of your explanation by complicating things. How many dots do we have to connect in order to be confident that we're right? So in this one, I want to suggest that the data actually may be more effective at explaining what advice companies are getting from their general counsels than it is about the impact of just the best foods. Because as Jeff indicated, Supreme Court opinions typically raise questions, shift the nature of the questions that are being addressed rather than resolve them. And I'll give you the example, it would be to compare best foods to another environmental disaster, the Exxon Valdez mess in Alaska, where Exxon dumped millions of gallons of oil in it. The boat was owned by a subsidiary of Exxon, but not for, it was a perfectly well-capitalized company. They owned, the boat ownership shifted around mostly for tax reasons. So there are a whole bunch of different environmental statutes that can be used to impose liability on these folks. So in Exxon, you had the rules against injuring migratory birds, which was a criminal violation. When the Justice Department brought the case, they actually didn't know that a subsidiary on the boat. And it was a criminal prosecution, so that they were criminally prosecuting the parent End result was they didn't use a piercing the veil theory under state law. The common lawyers in the room will know better than I do. They just used an agency theory. A subsidiary under the restatement of agency can be an agent of the parent, and the parent is responsible for all of the liability of the agent. It's an easy thing to prove, because you basically have to prove, you have to prove control and actions. A piercing the veil case requires you to know everything there is about the way a company operates. In a criminal case, you get no discovery, and the government had 2 lawyers doing it. In the end, after losing a motion to dismiss the indictment, Exxon, the parent, pled guilty to a crime. The calculation of damages isn't any different in that setting, and in any given setting, there are typically a bunch of different environmental rules that will cover something. So in a funny way, one of the differences that would be fun to know is whether, is to try to figure out what it was. So maybe the easiest way to put it is, what the law is what clients are told by their lawyers the law is. Not by their reading of a Supreme Court opinion. The lawyers, it's the lawyers' predictions about where the court's going to go. So here, you get the increases that you describe. My sense of it, my intuition about it, is that what you're getting, it's the impact of a not so straightforward Supreme Court opinion as refracted by the prism of the legal advice people are getting. So it becomes kind of one-off, and it becomes a very interesting issue, because the people act based on the legal advice that they get. And what you're showing is a real nice sense that they're getting advice that they can get away with more. Now, why it was only a single, why this was only Cercla, what other cases, what other laws applied, why the Justice Department chose to use Cercla and not everything else isn't obvious, but will turn out to make a whole lot of difference in terms of what advice they're getting. So complicating it makes the data even more interesting.
I think that's a really interesting interpretation. I haven't thought about it like that. No, but that's something we can think about some more. In terms of, we do spend some time in the paper discussing other environmental regulations, and I agree there is, to an extent, an overlap. I think Cercla in general was, at least when it was initially adopted, it was seen as filling some sort of void when it came to environmental law. And so I don't think sort of other laws necessarily perfectly substitute for it, but that is something we can think about some more.
So I was wondering, given that we saw that the subsidiaries then increased the pollution after the strengthening of the limited liability, are there any effects on the parents? Because you said that for some of the parents you actually have them being publicly listed, right? Have you checked whether you actually see movements in their stock prices?
Indeed, so we have looked at stock prices, and we pick up an effect around the oral arguments of Best Foods. It was a unanimous decision. We don't see any effect on the decision date, but we do see a positive effect of around 1% for the parent companies around the arguments. We don't look at, analyzing parent behavior here is a bit tricky because you can have subsidiaries located in different areas, and so we do sort of a weighting. I don't personally love that approach, but I think it's all we can really do. And so that's why we haven't spent too much time looking at sort of other accounting characteristics for parent companies.
I'm trying to figure out, I don't know, maybe you find some of the corporations actually only have subsidiaries owning plants in certain districts rather than the firms owning one of the others.
It is a pretty narrow sample, but I agree it is something we can spend some more time looking at.
Yeah. This is really interesting stuff, and I'm listening to the lawyers, and now I'm a little worried to say something legal that might be silly. It seems to me that the benefits of limited liability, the stuff that your economist quote refers to, and which I think is what makes this topic super interesting, is really about limited liability for public companies, not about limited liability for subsidiaries. And there's all kinds of reasons you have subsidiaries that has nothing to do with limited liability. You have tax purposes. You want a subsidiary in every state. If I buy a BMW in Spain, my counterparty is not the listed entity. It's some Spanish subsidiary, right? Now, if something goes wrong, I feel like BMW, the whole thing is my counterparty, and maybe that's legally reasonable. And I think courts do make that judgment in all kinds of settings, right? So it maybe saying, oh, limited liability kind of within these 1,000 corporation groups is maybe sometimes a little weird, doesn't really indict the whole idea of limited liability, you know, in the economy.
No, we're not trying to indict anything. I agree parent corporations form subsidiaries for all sorts of reasons, but I think at the same time, one of the main reasons is they have subsidiaries is as a liability shield. And so I agree sort of there is a difference between shareholders owning a public corporation and having limited liability and parent corporations owning subsidiary corporations. Yet I agree, like I think some of the same fundamental sort of incentives are playing a role here. And so perhaps we could tone down that opening quote a little bit, but I think they speak to a similar idea.
Did you observe these scandalous events increasing after its 1998? And also, you mentioned about the super fund. Have you observed whether they are spending on cleaning up the mess? Because you're finding 10 to 20% increase. And in 20 years now, time, there must have been a huge scandal now. Do you observe such things?
So we haven't spent too much time looking at the EPA behavior. Superfund has gone through sort of funding cycles. I think it was in the early 90s. Initially, it was funded by a tax on like the petroleum industry, and then they got rid of that tax, and so it's funded by the Treasury now. And so I think in general, enforcements have been going down for Superfunds simply because they don't have as much money. We haven't spent much time looking at the EPA behavior in terms of whether or not they're changing what they do in response to these liability questions. I think that's a great idea.
Seen from a continental lawyer's point of view, I find it's an interesting case, and I think our solution would be a bit different here. So I understand that a subsidiary has breached existing environmental mandatory law, right? And then the question is whether the holding company can be held liable by those affected by this breach of the environmental law by which they have had a damage. If the holding company has control of over the activities of the sub, then that includes this includes control whether the sub complies with the environmental law. And if that was omitted, then this is a tort of the holding company. So those affected by the negative actions of the sub would have an immediate tort claim against the holding company according to continental law. That has nothing to do with the piercing of the corporate veil or something like that. It also would take place if the subsidiary was well funded and well capitalized. So it has nothing to do with an abuse of taking a form of a subsidiary. It is simply, you cannot defer your liability by setting, well, this is an independent company, I control the activities, but I'm not liable for the outcome of that. So that would be a tort per se of the holding company. This has nothing to do with piercing the corporate veil. Let me add, the term limited liability is a bit of a misnomer. because if I have inferred the capital which I have promised to the subsidiary, I'm not liable at all. But I still remain liable for my own torts. So and I cannot defer my liability vis-à-vis third parties by, letting the subsidiary, giving instructions to the subsidiary, steering the activities, and then saying, well, but I'm not responsible for the damage which comes out of that. That would be the continental solution of the case. No piercing of the corporate veil.
I think it's something I would like to learn more about. I can only speculate on sort of the European approach, but I think in general the different approaches to this question are really interesting. And I think in terms of, to the extent we want to think about policy, perhaps in the conclusion, it would be interesting to make this sort of comparison.
If I may add, somewhat wrong theory may basically the same point. Yeah, I think so.
So a big part of the issue in these cases is with respect to legacy liabilities, where the toxic behavior took place decades before, and the fight is over who's going to pay for cleaning it up or for mitigating the problem. And what's interesting in your results, among others, is that you don't find an effect on the production, but you do find an effect on the steps that the subsidiaries are taking to mitigate. And that's consistent with the conventional wisdom of legacy liabilities. One issue that comes up in this area is whether this land that has been contaminated can ever be sold. And the problem, of course, with the owner-operator, putting the obligation of cleanup on the owner-operator is that if that's broadly construed, then nobody's going to buy the land, even if they have a use for it, for fear that they will be stuck with the complete cleanup costs. And the traditional corporate law respecting the legal separateness of the subsidiary is a way of cabining those liabilities within a subsidiary and thus potentially making the land more marketable. And it would be interesting to see if you can find any evidence in the data as to whether there was an increase in the marketability of contaminated sites post-Best Foods as compared to pre-Best Foods.
I think that's a really interesting question. I haven't even thought about it, but that's something I definitely want to take a look at.
No, I just wanted to add to the previous point that the Supreme Court did change the decision of the lower courts with respect to actions where the parent was directly responsible for the pollution. So that principle was recognized by the Supreme Court. The problem was just at that part which was not directly controlled by the parent. And whatever was the responsibility of the parent as directly involved in the operation, that's a separate thing. But the focus here is on the piercing of the corporate data.
Any more questions?
One final point is that after the Best Foods case, many states adopted their own version of the Superfund statute in a way that that overturned the case for the state law statute. And New Jersey is the big example of that. And there's been a lot of pollution over time in New Jersey, making it the butt of jokes. But and one thing you could do in your work is to see where the plants are. And so if the plants are, and look and see which states adopted more robust versions of cleanup statutes, and see if the plants where you find your reduced pollution abatement effects have a state law element as well as the other diff and diff that you're focusing on.
I think that would be great.
Any last words, Ian?
No, thank you very much.